Hello, and welcome to this webinar, the administration's recent Tailpipe Rule, Law and Policy. So last Thursday, the U.S. Environmental Protection Agency and the National Highway Traffic Safety Administration announced a final rule to determine that California may not adopt or enforce regulations of carbon dioxide emissions from motor vehicles. This rule upends nearly 50 years of clean air policy, and it disrupts an area of climate policy that's been relatively stable for about a decade. So the rules also determine that California's zero emission vehicle program is also preempted. The following day, the state of California and 22 other states, along with the cities of Washington, D.C., Los Angeles, and New York, also filed suit challenging the rule. During this 1 hour webinar, we're going to explore the legal and policy issues that this agency action raises. So I'm Greg Dotson, and with the University of Oregon School of Law, I'm joined by Jack Lienke of the Institute for Policy Integrity at NYU School of Law, and also by Julia Stein of the Emmett Institute on Climate Change and the Environment and the UCLA School of Law. This webinar is sponsored by the Emmett Institute on Climate Change and the Environment, the Institute for Policy Integrity at NYU School of Law, and the Environment and Natural Resources Law Center at the University of Oregon School of Law. So over the next hour, we'll hear from Julia Stein, Jack Lienke, and myself. And given the format, we'll save questions from the audience for the end. You're welcome to submit questions via the chat function on your screen, and please feel free to designate your question for a specific panelist if you'd like. So with that brief introduction, I think we should go ahead and get started. You probably overheard us in the beginning saying we have more information than we know how to present. So with that, let's get started. Julia Stein of the Emmett Institute.
All right. Okay, so as Greg mentioned, I'm Julia Stein. I'm the project director at the Emmett Institute on Climate Change and the Environment and the clinical supervising attorney at the Frank G. Wells Environmental Law Clinic here at UCLA School of Law. And today I'm going to kick us off by covering the California perspective on the Tailpipe Rule saga, starting with a little background to contextualize the California waiver, and then moving into a high-level discussion of the lawsuit that's been filed by California and a number of other states and cities. I'll be mostly steering away from a discussion of EPCA and Clean Air Act Section 209. I know Greg and Jack will be devoting considerable time to that later this hour. So to get started, a little bit of background information on the California waiver. California's right to set its own tailpipe emission standards is no new thing. It has a long history. That history starts around the 1940s when metropolitan areas in California were suffering from some of the worst air quality in the country. At first, that poor air quality was ascribed to stationary industrial sources like refineries, but in the 1950s, research began to show that in reality, a combination of unique geographical, topographical, and climate conditions and emissions from cars and trucks were a major cause of that problem. So armed with that knowledge, California began its efforts to regulate vehicular emissions in 1959 and adopted tailpipe emission standards effective beginning in 1966. Around that same time, the federal government began its efforts to regulate tailpipe emissions, and the first such federal standards were adopted in an amendment to the Clean Air Act in 1965. But at that time, Congress didn't make any effort to preempt other state standards. In 1967, responding to calls from the auto industry to prevent a patchwork of state standards, which is a theme that might sound a little familiar to you given the past couple of weeks' events, Congress adopted language that did preempt state standards except California's. Instead, Congress specifically recognized California's unique efforts to address tailpipe emissions with a waiver provision, allowing California to adopt its own standards. Legislative history from the time emphasizes that legislators were not only aware of, but sought to preserve California's role as a regulatory innovator in this space. And since adoption of that waiver provision, which I know Jack is going to provide more detail about later, California has sought and been granted more than 100 waivers. Congress even strengthened the waiver provision to be more favorable to California in the 1970s. And as you'll hear more about later, the waiver provision presumes California will be granted waivers when it applies for them, and a waiver has never been revoked before in the entire 50-year history of the Clean Air Act. So with that background in mind, what's today's fight about? On a very high level, it's about a couple of big picture questions. One is how we think about California's longstanding waiver right that we just discussed. And another is the way in which regulating greenhouse gas emissions from cars and trucks specifically intersects with federal regulation of fuel economy. Jack and Greg will dig more deeply into both of those questions later, but for now, I'll say that the rule represents a significant departure from how the agencies and courts have historically thought about both the waiver and federal regulation of fuel economy. This is really an unprecedented action by the federal government and could have repercussions beyond just this waiver. More specifically, though, this fight is about a waiver that was granted 6 years ago for a set of emission standards that California collectively refers to as the Advanced Clean Cars Program. Those emission standards are made up of three component parts. First, the LEV 3 standards, which cover criteria pollutant standards, such as those for particulate matter and oxides of nitrogen. Second, the LEV 3 GHG standards, which cover emissions of carbon dioxide equivalent, which is measured by combining emissions of carbon dioxide, methane, and nitrous oxide. And finally, the Zero Emission Vehicle, or ZEV mandate, which requires automakers to produce a number of ZEVs and plug-in hybrids every year based on their total overall auto sales in California. Here, the administration has said it is issuing a partial waiver denial. So the denial is focused on the LEV 3 GHG standards and the ZEV mandate, but not the LEV 3 standards for criteria pollutants. Typically, the entire set of standards is considered together for purposes of waiver determinations. So this splitting apart of the Advanced Clean Cars Program into its component parts is also a departure from past agency practice. So who stands to suffer from the agency's action here? A lot of different parties. Of course, California does. Withdrawing the waiver significantly impacts its ability to meet federal air quality standards and its ambitious climate targets. California uses the Advanced Clean Cars Program as a key way to fight soot and smog, and it's also an important part of California's plan to meet its 2030 GHG reduction targets. It's particularly ironic that EPA has picked this week to point out California's ongoing struggle with smog pollution, just as it takes away one of the major regulatory tools to combat that pollution. In that vein, the public will also experience significant harm, both from the public health impacts of soot and smog pollution, so thinking increased asthma cases, for example, and from the worsening effects of climate change. And it's not just California citizens that are impacted, because a number of other states follow California's standards through Section 177 of the Clean Air Act. Those states are impacted as well. They are among the states that have sued the administration along with California. And finally, the rule harms the auto industry. Finalization of this rule is triggering a prolonged period of regulatory uncertainty for automakers who were previously governed by one harmonized standard. They've relied on the waiver as well as they've made business plans for the last several years, and the administration's action stands to undercut significant investments that many of those companies have made as they respond to market trends favoring more fuel-efficient and greener cars. We saw the auto industry itself make these points in public statements and in a hearing before the House Energy and Commerce Committee earlier this year. So in the interest of time, I'm not going to spend too long on this slide, but I did want to raise a few of the common myths that we've seen from the administration over the course of the rulemaking process, and again this week during its rollout. Among them are the theme that California is forcing itself and its standards on the rest of the country, and that the agency's action will make cars cheaper and safer. Just a little bit of a brief debunking here. California doesn't have the right to impose or enforce standards anywhere but California. It's true that California is a major car market, but there's also a 50-year-long history of California having its own separate tailpipe standards, and that has not controlled regulation or the types of cars sold in other states. In other words, California is not trying to bully the rest of the country here. What's more, because the California and Obama-era standards are harmonized, even though the agencies have claimed they're creating one national standard, they may actually be doing the opposite. There is one national standard right now, but the outcome of future litigation could mean that one standard goes away. As for the points on cost and safety, it's been well documented that the California and Obama-era standards are cost savers over the life of a car, and that the safety gains the administration claims, particularly those associated with the rebound effect or the idea that people will drive more because their cars are more fuel efficient, are specious. Okay, on to the litigation. What is a lawsuit that was filed on Friday? Although the Thursday rule published by NHTSA and EPA, as Greg mentioned, covered both EPCA preemption of the California regulations and revocation of California's waiver, the Friday lawsuit only challenges the first of those two parts, the EPCA preemption rule finalized by NHTSA. That means litigation on the waiver revocation itself is yet to come. The lawsuit was filed in district court in Washington, D.C., where all of the named defendants have residence. Also notable is the large group of plaintiffs who signed on to the complaint. So not just the Section 177 states that adopt California standards, but also other interested states and cities too. That large plaintiff group really underscores the significance of the action here. The lawsuit itself asserts claims under the Administrative Procedure Act and alleges the EPCA preemption rule is an action outside the regulatory authority of NHTSA. Most of the claims have to do with EPCA, and because Greg is going to spend a significant amount of time talking about EPCA, I'll spend just a little bit of time here focused on the APA claim that doesn't deal with it, the claim that the agency did not comply with NEPA when it promulgated the rule. NEPA is a federal statute that requires federal agencies to evaluate the environmental impacts of actions that they take. Here, the plaintiffs are claiming that the agency never did that. The agency instead said NEPA didn't apply to the rule at all. But NHTSA has historically recognized factors like impact on state environmental regulations and increased emissions, both of which are at issue here, as triggers for NEPA review. And in 2008, in Center for Biological Diversity versus NHTSA, which was a challenge to NHTSA's adoption of the 2006 Federal Corporate Average Fuel Economy Standards, the Ninth Circuit explained that EPCA does not limit NHTSA's duty under NEPA to assess the environmental impacts, including the impact on climate change of its rule. In that case, NHTSA had prepared an environmental assessment under NEPA, but the court found that it did not adequately assess the environmental impacts of the rule. The court concluded that NHTSA did not adequately consider cumulative impacts of greenhouse gas emissions or reasonable alternatives to the rule. It ordered NHTSA to engage in that analysis and either revise its environmental assessment or, if needed, prepare an environmental impact statement, which is a more rigorous environmental review document. In the case of Thursday's rule, the agency didn't even go so far as to prepare an environmental assessment in the first place. It didn't engage in any NEPA review at all. So past agency practice and court precedent seem to support an argument here that the agency did not comply with NEPA. And finally, what's next? A brief snapshot of what might be coming. So first things first, litigation is going to move forward on Friday's suit. The first phase of that litigation might be a motion to dismiss filed by the federal government. And then as that litigation moves forward, we're also likely to see other litigation that challenges the waiver revocation. The venue provisions of the Clean Air Act mean that litigation should end up in circuit court from the get-go, but there is still plenty of time to file that lawsuit. Thursday's rule isn't final for 60 days after publication, and after that, potential plaintiffs have a 60-day window to sue the government. As in the EPCA case, we may see other states and groups join a lawsuit on the waiver revocation too. And finally, the question that everyone's been asking, do we get to the Supreme Court before the 2020 election? It certainly seems likely that the Department of Justice will try to expedite the litigation process, but even moving quickly, it would be a stretch to get to an oral argument on Friday's case before the November election. So with all that, I will turn it back to Greg.
Great. Thank you so much, Julia. I'll just mention again that you're welcome to submit questions via the chat function on your screen. So now let's go to Jack Lienke of the Institute for Policy Integrity. Jack, I think you're still muted.
Sorry about that. Let's try again. Okay, and now my slides are up, I hope. So I'm going to focus on revocation authority under the waiver provision in the Clean Air Act, Section 209. And is that a thing? Does it exist? If so, when can it be used? And I think an important thing to keep in mind when you're thinking about this attempted revocation and the cases that will come out of it is that the year is not 2013. And what I mean by that is that the question here is not whether EPA can deny a waiver request from California, right? Because it granted a waiver to California in 2013 for standards that run through model year 2025. And so thinking about the grounds on which EPA can deny a waiver is not the right way to approach this problem, because the question here is, can EPA revoke a waiver that it already granted California almost 7 years ago? Which is a very different question. Because here's what the Clean Air Act says about the circumstances under which a waiver can be denied. It's a long statutory provision. I'm not going to read it to you. Instead, I'm going to translate it for you. But the Section 209 basically requires EPA to grant a waiver request from California unless it finds one of three things. First, it could find that California's own conclusion that its standards in the aggregate, all of its motor vehicle standards considered together, are at least as protective as federal standards. So EPA could have found that California's standards, California's finding that its standards were at least as protective was arbitrary and capricious. And the framing there is important. It's not a finding by EPA that California's standards are not at least as protective as federal standards. It's a finding by EPA that California's conclusion was patently unreasonable, right? That it was arbitrary and capricious. So there's more deference to California built in there. The second grounds would be that California does not need its standards to meet compelling and extraordinary conditions. And I'll talk a little later about what that means. And the third is that California's standards are technologically infeasible. There's not adequate lead time. So those are the very limited grounds on which EPA can deny a waiver request under the Clean Air Act. And in more than 50 years of the waiver program, EPA has fully denied waiver only once, a decision under the George W. Bush administration that was subsequently reversed by the Obama administration. So that's what the Clean Air Act says about grounds on which EPA can deny a waiver request. And here's what the Clean Air Act says about circumstances under which EPA can revoke a waiver. That slide was intentionally blank because the Clean Air Act says nothing about EPA's authority to revoke a waiver. And if we could talk, I'm conscious that I have limited time here, so we could talk about the text of the statutory provision, about the conditions under which a waiver can be denied and how it implies that this is a temporally limited situation. It shall not be granted if one of these findings is made, not that the waiver shall not be maintained, not that California shall not continue to hold a waiver. But we're gonna move on. But another important thing that Julia already noted is that in the 50+ years of the waiver program, EPA has never before tried to revoke a waiver. Nonetheless, despite the lack of any textual authorization, despite the lack of any precedent for doing so, EPA now claims that it can exercise inherent authority to revoke the waiver that it granted California in 2013, or at least to revoke the portions that Julia mentioned earlier, the LEV 3 GHG standards and the zero emission vehicle standards. But there's case law on inherent authority to reconsider decisions. And it is true that there are some circumstances under which agencies can exercise inherent reconsideration authority, but there's also ample case law that suggests there are circumstances under which they cannot. And there are three reasons here to think that EPA cannot do so in this situation. One is that the case law on inherent reconsideration authority emphasizes that the decision to reconsider needs to take place within a reasonable period of time, right? Oh, we realized that we made a mistake in that recently issued decision, we're going to fix it. Here it's been 7 years. The fact that it's been 7 years points to the next factor, which is that there's ample case law that shows that reliance interests can weigh against a finding of inherent reconsideration authority and revocation authority. Here, California has relied on the waiver that it was granted through model year 2025, in developing plans not only to meet its own greenhouse gas reduction goals under state law, but also in developing plans to comply with federal ambient air quality standards for traditional pollutants, right, for soot and smog standards. And perhaps if a waiver had been denied in the first place, California could have developed alternate plans for achieving those goals, right, by focusing on other sources. But now it's had 7 years where it's been counting on having those standards in developing its plans, and to yank it back now severely disrupts those reliance interests. There are other reliance interests. Several municipal planning organizations and localities submitted letters to EPA saying that they relied on the existence of the California standards when they were demonstrating conformity with federal air quality standards for purposes of receiving federal transportation funds, right? So yanking these standards back now would put $130 billion in transportation funding at risk in California alone. And then a third factor here are the federalism concerns, right? We're not just dealing with private reliance interests, we're dealing with the reliance interests of a state government that has a sovereign interest in protecting the health of its own citizens. So those are reasons to think that even if there are some circumstances in which an agency can invoke inherent authority to reconsider a decision, it can't do so here. The next thing I'd say is that even if we assume that EPA has authority to revoke a waiver on some grounds, right, there are some permissible grounds for revocation that we could identify. That is not the same thing as saying that EPA can revoke a waiver on any grounds. And the next is that even if EPA was citing a theoretically permissible grounds for waiver revocation, it also has to make findings that are legally and factually defensible. That should be factually, not factual. But that is, if we were to assume that a finding of technological infeasibility could be a grounds for waiver revocation, EPA would need to show that it was not arbitrary and capriciously concluding that that California standards were in fact infeasible. And actually, it probably would need to show more than that because of the deferential standard for the deference that EPA traditionally shows California in waiver proceedings. All of which is to say that there are multiple ways for EPA to lose this case, right? It can lose this case because it doesn't have revocation authority, full stop. It could lose this case because it has revocation authority. It could permissibly cite revocation authority under some circumstances, but those circumstances are not present here. It hasn't cited permissible grounds. Or third, it's citing a theoretically permissible grounds, but it hasn't developed the record necessary to support the findings that it's made. And just quickly, in the proposed revocation last summer, EPA cited 3 grounds for revocation, right? It cited the NHTSA finding that state greenhouse gas standards are preempted under EPCA, which Greg will talk about, and I won't talk about EPCA. The next was that California does not need its standards to meet compelling and extraordinary conditions. And the third was that California standards were technologically infeasible, right? That there was not adequate lead time. In the final version, EPA has abandoned that third justification, right? Feasibility. And that is tied to the administration's inability to deal with all of the concerns that were raised in response to the modeling that it did in support of its proposal last summer to weaken federal greenhouse gas standards, right? So it's arguing that that both the existing federal greenhouse gas standards and in that proposal and EPA's and California's standards are infeasible, but it can't make the numbers work, right? It can't justify that conclusion. It's struggling to do so. And so here it's chosen to proceed with a revocation without the weakening of federal standards. And because it doesn't have that record to support a finding of infeasibility, it's completely abandoned the feasibility rationale. On these two other grounds, I would say on EPCA, I would just note that if you think back to that slide I showed you where there were the permissible grounds for denial, right? Those are the three grounds. Courts have suggested that EPA cannot consider any other factors in deciding whether to grant a waiver or not. A consideration of whether the standards are preempted under EPCA is not one of those factors. It would be very strange for EPA to be able to revoke a waiver. Again, we're assuming that it can revoke it all, but it would be very strange for EPA to be able to revoke a waiver on grounds that it could not cite to justify denial in the first instance, right? Because then that would be a complete runaround of Congress's carefully crafted waiver program, right? Under which denial can only be justified on these very limited grounds because we want to be very deferential to California, right? Because you could issue a waiver on Tuesday and then say on Wednesday, yeah, but now I'm going to revoke it and I'm going to consider all these factors that I couldn't consider yesterday. So that's just a theoretically problematic thing. On the second, the need for standards to meet compelling and extraordinary conditions, we could talk a lot about this. All I'll say here is that what EPA is arguing is that California doesn't need its own greenhouse gas standards because greenhouse gas pollution is a global problem, right? It's not a localized pollution problem. And so California doesn't have a special greenhouse gas pollution problem that requires special California standards in EPA's view. The first thing I'd say about this is that EPA has never approached this prong of the test as, does California need this particular standard and this particular waiver to meet compelling and extraordinary conditions? How EPA has always approached this issue for 50 years is, does California need its own motor vehicle air pollution program with many interlocking parts to address compelling and extraordinary conditions in California? So we don't ask, does California need greenhouse gas standards? And does California need nitrogen oxide standards? We ask, does California need its own set of standards? And then, are those standards considered together collectively at least as protective as federal standards? Those are the questions. So here, EPA is trying to say, well, for greenhouse gas standards, though, we're going to do it differently. We're going to say, do you specifically need greenhouse gas standards? So inconsistent with, and inconsistent with the statutory text for reasons that are too complicated to get into here. But even if that were the case, when the Obama administration issued the waiver in 2013, it found, one, when we consider the California program as a whole, which is the appropriate way to consider it, obviously California has compelling and extraordinary conditions that require it to have its own motor vehicle air pollution program. But EPA also made an alternative finding, which was, even if we looked just at climate change impacts, California does have compelling and extraordinary conditions related specifically to climate change, and it needs its own standards to address those. So even if EPA can get away from this traditional approach, even if it can justify that, it still then has to show that California doesn't have compelling and extraordinary climatic conditions, which I think is a very heavy lift for the agency. And with that, I am out of time, and I will turn it over to Greg.
Great. Thank you, Jack, so much. That was terrific. And I'll just do one last reminder. If you have questions for any of us, you can feel free to add them to the, to give them to us via the chat function on your screen. We've already gotten a few questions, and we'll be answering those in after my brief presentation. I am just going to bring up my slides here. Great. Okay, so I'm going to be talking about EPCA prevention over the next few minutes. And I got to figure out, here we go. And what I'm going to briefly do is provide an introduction to the Energy Policy and Conservation Act of 1975. That's EPCA. I'm going to discuss NHTSA'S historic views on the issue of preemption, including the new position that they finalized last week. I'll briefly assess the legal merits of their position. And finally, I'm going to discuss the relevant legislative and statutory history. The Energy Policy and Conservation Act of 1975 was prompted by the oil embargo of 1973 and 74. The purpose of the act, it did seek to increase production of oil in the United States, but a key part of it was to boost oil conservation. And it was responding, the goal was to respond to sort of the contemporaneous economic challenges of oil shortages by increasing conservation. The goal was to become less dependent on oil. President Ford had actually announced a goal of reducing the US imports of oil by 2 million barrels per day. And it was also to introduce a more sustainable approach to utilizing the nation's oil resources. So the purpose was not to address clean air, it was not to improve air quality, it was not to address climate change. And this EPCA included a mandatory fuel economy program, also known as the Corporate Average Fuel Economy Program, or CAFE. And it's important to note that during this time, the Clean Air Act had just been established in 1970, and clean air was clearly a national priority. It was an active progress in Congress. So there was legislation being pursued and enacted in the years right around EPCA, signed into law in 1975 by President Ford. Clear that reflecting that priority of clean air, the structure of EPCA was such that it was designed to not interfere with the clean air project that Congress was embarking on. It explicitly provided for fuel economy standards to be adjusted if necessary to accommodate automobile emission standards. So the mandatory fuel economy program included this preemption language, which is a key part of the litigation we're now considering. And it's a 50-word clause. It says essentially that when a fuel economy standard is in effect, states and localities cannot adopt any law or regulation related to those standards. And so the key question really is, what's the proper interpretation of this preemptive language? How expansive did Congress intend it to be? What does relating to mean? Well, we do have two federal court cases on that, both from 2007. One, they used a slightly different legal rationale, Green Mountain, Chrysler, Dodge, Plymouth versus Crombie in the District of Vermont, and Central Valley Chrysler Jeep versus Goldstein. And those cases both determined that state greenhouse gas emission standards were not preempted under EPCA. But we can also look to other, other information. What's NHTSA's historical views been on preemption? And I think if you were to read the EPA DOT final rule, you might get the impression that the rule, is sort of a long-held view of the agency, and that would not be accurate. NHTSA has never before taken final agency action asserting the California emission standards are preempted by EPCA. And from the first rulemaking after EPCA was enacted in '75 through the rules governing model year 2011, NHTSA has considered the fuel economy effects of California emission standards, and it's simply adjusted the fuel economy standards as necessary to accommodate California emission standards. Congress was not surprised by the fact that California standards could have an effect on fuel economy. When they were acting on EPCA, they received testimony from the National Academy of Sciences that California standards affected fuel economy by 5%. And and as we saw, there was consistent implementation to adopt that. For model years 2012 through 2025, the federal standards and state standards were harmonized. So this issue largely didn't have to be addressed. However, NHTSA is correct that there has been some discussion of preemption over the years. In 2002, the proposed rule for model years 2005 to 2007 talked about how a state could not do a regulation relating to fuel economy if it served the same public policy concern. Well, EPCA was not designed to address climate change. It was not designed to protect public health and welfare. So under that test, we wouldn't see, I think, a credible EPCA preemption argument. In 2006, for the final rule for model year vehicles 2008 to 2011, NHTSA did finalize a statement in the preamble saying that, that there would be a preemptive effect, but that rule was remanded by the courts, and the preemption discussion was not a final agency action. And then in 2008, in the waning days of the George W. Bush administration, there was a proposed rule that, like the rule finalized on Thursday, would have put in regulatory text to determine the state tailpipe CO2 standards were preempted. That rule was never finalized. None of these rulemakings contemplated preemption of California's zero emission vehicle program. So really what we're seeing last week is a new theory, much more expansive than has ever been contemplated, and a real change from 50 years of practice. The agencies essentially argue that, that because a car that goes farther on a gallon of gasoline emits less CO2, and a car that when you regulate CO2, it goes farther in a gallon of gasoline, these are inherently related, and therefore EPCA's preemption is very broad, and it preempts all state and local laws related to fuel economy standards or average fuel economy standards. This leads to the scope of the preemption in the final rule, and it essentially says that it applies in two different ways. One is that a state or local law regulating or prohibiting tailpipe carbon dioxide emission standards are expressly and impliedly preempted. And then also more broadly, that any law or regulation having the direct or substantial effect of regulating or prohibiting tailpipe carbon dioxide emissions are also preempted. Well, in their rule, and I'm going to, for the sake of time, I will proceed here. In their rule, the agencies essentially rely upon a line of cases involving EISA. And there we have a string of cases, the Supreme Court, that interpreted the phrase related to. Now, in my opinion, they misapplied the Supreme Court's approach. They apply, the Supreme Court has said, you need to look at what the scope of the state law, what was the purpose and effect of the state law, and what did Congress expect to remain of the state law after enactment. I think that we have multiple decades of without any apparent controversy, without any intervention by Congress or even a statement of Congress of concern of NHTSA applying EPCA in a way that provided for California emission standards. And so I don't see that that test being applied correctly. And by the time the Supreme Court is really done with EISA, they have backed away from the broadest interpretation of the related to language. Justice Scalia, in a concurrence in a case called California Division of Labor Standards, says that applying the relate to provision, according to its terms, was a project doomed to failure, since as many a curbstone philosopher has observed, everything is related to everything else. And so they lead to a more nuanced approach, which I believe that NHTSA and EPA are failing to incorporate. I have a lengthy discussion on this, as well as the other issues associated with this rule in a forthcoming article, Environmental Law Reporter. So I would commend that to your attention. It'll be out in November, called State Authority to Regulate Mobile Source Greenhouse Gas Emissions, Part 1, History and Current Challenge. The agencies also introduced a very problematic exception where they say that, a state safety standard with a merely incidental impact on fuel economy do not relate to fuel economy for purposes of EPCA preemption. And so here they are attempting to wield this preemptive clause, which has which does not appear to contemplate any state, or I'm sorry, any agency role in its implementation. There's no delegation of authority to NHTSA to determine the scope of preemption or to weigh preemption in any way. And here they are creating an interesting exception which does not otherwise appear in the statute. And it begs the question of what does it mean? Is it merely incidental in sort of scope of effect on fuel economies, or is it merely incidental in that it's a secondary effect to the purpose of the state law? They don't explain that. And I think it results in a problem for them in that they come up with an approach that is really not logical or coherent, and it raises lots of questions about other state standards or other state laws that could be impacted by this rule. 9 states have adopted anti-idling rules. These are laws that basically prohibit the idling of automobiles. And according to the US Department of Energy, idling vehicles is responsible for wasting approximately 3 billion gallons of gasoline and emitting approximately 30 million tons of carbon dioxide per year. So these laws and regulations, would appear to be preempted under the interpretation proposed by the agency, since the state or local prohibition would have the direct effect of prohibiting tailpipe carbon dioxide emissions in certain situations. Speed limits certainly do not have an incidental effect when it comes to the amount of effect on fuel consumed. Researchers show that when you increase fuel economy or speed limits, to 70 miles per hour as opposed to 60 miles per hour, you use up to 16% more gasoline. And so, what is the effect of this? NHTSA does not provide any clarity that can help states understand the scope of their preemptive activity. Gasoline taxes is another one. We know from economic modelers that imposing a gasoline tax, which every state does have an effect on gasoline consumption. And there's an interesting string of cases involving taxi cabs from New York City which specifically looked at EPCA preemption issues. And the court essentially said that you could look beyond the text of a statute to see if there was a hidden purpose. And there, the court found that the taxi cab and limousine commission in New York City was essentially making an offer that the taxi cab owners couldn't refuse, which was a series of rate structures essentially to require more efficient vehicles. Well, you begin to wonder whether that looks like a gasoline tax, and if so, are they potentially taking actions here that could affect the 50 states' gasoline taxes? And then there's of course other laws as well. I've talked about some of those in my paper. I will, for the sake of time, skip those now. I have a second paper which is coming out in 2020 in the Georgetown Environmental Law Review, which goes into the legislative and statutory history of this issue. And essentially, to hear NHTSA and EPA talk about it, Congress acted in 1975, and then they acted in 2007, and that's the complete lay of the land. Well, they're really failing to identify, discuss, or clarify any of the other key statutes in which there has been both legislative history and statutory history that is pertinent to this question. So the Clean Air Act amendments of 1977 expanded and reinforced the tailpipe authority. There is great committee language, conference report language on the issue of Congress's intent to provide the broadest possible discretion to California in setting these standards. The Clean Air Act amendments of 1990 actually recognized California's zero emission vehicle standards, which had come out that had been promulgated by the state earlier that year. And there Congress said, we want to build off of what California has done. We're going to have a new clean vehicle fueling program in certain non-attainment areas. And we want EPA to model their approach off of California's zero emission vehicle standards, it would be quite odd to have California, to have Congress say that sure, we preempted them in 75, but now we're going to allow their program to run in parallel and in fact build off of that. The Energy Policy Act of 1992 included numerous programs to encourage states to develop EV programs, specifically alternative fuel programs, which include EVs, including a proposal incentives to encourage states to adopt any kind of program that would promote alternative fuel vehicles, including EVs. So it does contemplate mandatory programs as well. And so again, you have this situation where it's very much clashes with and is in tension with the rule finalized on Friday or finalized on Thursday, where the administration is now saying these state EV programs are preempted when in fact Congress sought to encourage them in 1992. The Energy Independence and Security Act of 2007 is probably the best example because with that law, we have numerous examples both of legislative history and statutory history about how Congress did not choose to preempt California. So, just briefly on the issue of legislative history, I believe, and my paper in the Georgetown Environmental Law Review paper, I believe, shows that convincingly that there is congressional, let me go back to this. Sorry, I didn't realize I was going to show you all my secrets. It does convincingly show that that there was a congressional intent to protect California's authority. But even if you reject that legislative history, even if you're a textualist and you say, I don't care about what members of Congress say on the floor, I don't believe committee reports matter, I don't believe in any of that, then quite separate, I have this quote from Scalia and Garner from their book, Reading the Law. Quite separate from legislative history is statutory history. The statute's repealed or amended by the statute under consideration, and these form part of the context of the statute, and unlike legislative history, can properly be presumed to have been before all the members of the legislature when they voted. And there are examples that I detail in my paper since 1975 of that kind of evidence. The EISA savings clause is a key one. So this is in the Energy Independence and Security Act 2007. Essentially, it says nothing in the act modifies the authority of the states to establish these emission standards. And the agencies say, well, this is because Congress could have amended the preemptive clause of EPCA, and they did not. This shows that they were trying to preserve the fact that states were all preempted. Well, I really think that the agencies failed to consider the posture under which Congress considered and developed and enacted this language. And so I have this brief little timeline to help illustrate that. In 2007, there was a proposal in Congress to repeal state authority to establish greenhouse gases. That was immediately objected to by the states, and it was rejected by Congress. It saw no legislative action. In September of 2007, we saw the Green Mountain case come down, in which federal court rejected the idea that EPCA preempted state greenhouse gas standards. In November, as documented by a recent, as documented in my paper, which cites to the original sources, Congress, rejects behind the scenes efforts from proposal from the automakers with the support of the White House to repeal state authority to establish greenhouse gas emission standards. On December 6th, the White House issues a veto threat unless they remove EPA and the state roles over greenhouse gas emission standards. Just 1 week later, we see the Central Valley decision in which, again, a federal court rejects the idea that EPCA preempts state greenhouse gas authorities. And within 2 days, we see what the press reports as an 11th hour gambit to amend the Clean Air Act and take out the state and EPA roles. And that fails. So I think under that context, it's very difficult to see how the burden is upon this clause to illustrate that Congress I think it's clear that Congress believed states had this authority, and that was supported by repeated federal court cases, and it reflects the state of the negotiations between Congress and the executive branch. So I think with that, I think we can spend these last few minutes taking questions. Yeah, I can see. So I think I have.
And then we'll have Q&A, there's one in there too.
Okay. Let me go ahead and read out some of these questions, and we will let folks participate. 1 second. Okay. I'm going to have to, I think I have to stop sharing my screen to do this. Okay. Okay, first question is, how does this affect states that want to put in clean car standards? Minnesota's transportation department recommended we implement them here. Who would like to take that question?
I'm happy to take
I'm
that.
happy.
Julia,
Oh yeah, go for it, Doc.
Well, so one thing we didn't talk about is Section 177, which was added to the Clean Air Act in 1977, which allows other states to piggyback on California standards, right? It gives them the choice between federal standards and California standards. They can't set their own standards. Only California has that special ability to get a waiver to set its own standards, but other states can follow California standards. And and more than a dozen have with respect to the GHG standards, and I think 9 with respect to the zero emission vehicle standards. And so, the 2 important implications, right? If EPA succeeds in revoking California's waiver, well, there are no standards to piggyback on under Section 177, but also in the final rule, EPA has advanced a new interpretation of Section 177 itself, saying that states cannot piggyback on California standards if they're greenhouse gas standards, right? And they have a theory as to why Section 177 wasn't intended to address kind of non-criteria pollutants. So that sets up a situation in which theoretically you could have California keep its waiver, but have other states lose the ability to piggyback on California's standards. And I would just say, if you want to learn more about this issue, Caitlin McCoy from the Harvard Energy and Environmental Law program has a great blog post specifically on this issue, because it's one that hasn't been talked about as much. And so I recommend that.
Great. Anything you add to that, Julia?
No, I think Jack covered that nicely.
Great. Let's see. I have a question here about will we have access to the PowerPoints after the call? I'm willing to make mine available if you are.
I'm happy to do that once I correct that.
Yeah, of course. Yeah, happy to do that.
Fabulous. We might all have some slight polishing before we make them public, but we'll do that. We'll do that quickly. And I think we, as a practical matter, I think we have gotten emails from those of you who've joined it, and so we can have a follow-up email that provides some additional access to the PowerPoints and also potentially other resources. Here's a question on reliance. What do you make of the final waiver repeals language on reliance?
I find it unpersuasive. I think one thing that I think is particularly outrageous is that EPA is now citing the things that California has done to protect itself since EPA proposed waiver revocation, like eliminating the deemed to comply provision of California standards, so that if federal standards are weakened, California, it's clear that California's standards still must be complied with, and also the voluntary agreement with automakers, regarding kind of voluntary emission standards that certain automakers have suggested, have released a statement of principles, I think, that they would comply with even if federal standards are weakened. I think I was trying to think of a good analogy for this, and I think it's as if your landlord has threatened to turn off your heat, and you've said, that's illegal, you know, New York City law requires you to provide me with heat, but also you order some blankets on Amazon, and then your landlord says, see, you definitely don't need heat, you have all these blankets, right? It's just absurd that EPA is saying that undercuts the notion that California is relying on these standards, because look, California is already making provisions for how it can get by without them. Obviously, that's simply not the case, right? That like California would prefer to have its standards in place. That's what it's been making decisions based on. And the fact that it's trying to mitigate the extreme harm that this decision would do to the state doesn't mean that it's not relying. Sorry.
Great, thank you very much. I have a similar question about the 177 states. I really think it's been answered, but maybe one aspect of it, well, I'll just read the question. I think there is one aspect of it that we could add to. What can New Mexico and other Section 177 states do now with regards to signing on to stricter standards? Can they continue to enforce the stricter standards in the face of the revocation? And I think, you know, I guess my answer to that would be that I don't think we yet know whether I think we'll be looking at the early days in the litigation to see whether the effect of this rule is enjoined or whether it goes into effect. And I don't think we know that yet. Does anyone have something that would add to that point?
Yeah, I think that's right. The only other thing that I would say is that the administration is certainly taking the position that the regulations are void ab initio, so that they are invalid as of the time that they were adopted, and that would suggest that they're going to take the position that anyone who then piggybacked off those regulations doesn't have the right to be using them during the pendency of the litigation unless a court stays the rule while making a determination.
Okay, great. Are there any other questions? We are coming up to the hour, but we probably have time for one more if there are any. Great. And Julia, Jack, anything you'd like to add to close out the webinar?
Just one thing I'd flag is that if you're interested in more detail on these revocation issues, Policy Integrity has a report that you can find on our website called No Turning Back. That's a much more in-depth analysis of whether EPA has authority to revoke a waiver, and if so, under what circumstances. And also, I know that the Emmett Institute has a report as well, and I would recommend both of those to you.
Yes, thanks for that plug for the Emmett Institute, which I was going to do if you didn't, Jack. And we have some publications out by Ann Carlson and others as well with the American Constitution Society that are worth a look as well.
Great, thank you for that. And I guess I'll join the bandwagon and just say that the two articles that I mentioned are up on my SSRN page. They are pre-publication versions, but they do have the information that I mentioned, that I discussed in today's presentation in them. Well, thank you all for joining us. We really appreciate it. I hope you found this useful, and feel free to be in touch with us by email if there's additional questions that we can help you with.
Thank you.